these particular accused persons.
Following the arrest of the former Butambala County Member of Parliament, Muhammad Muwanga Kivumbi, and 22 co-accused on charges of terrorism, the accused applied for bail before Justice Susan Okalanyi at the International Crimes Division of High Court in Kampala. Prosecution opposed the application, arguing that the accused are likely to interfere with the ongoing investigations, that the charges against them are grave, and that their release would pose a threat to the public safety.
And another as a person arrested while in or around Butambala at the material time. Now the application. The applicants filed for bail under Article 23 of the Constitution, Section 15 of the Trial on Indictment Act, Section 37 of the Judicature Act, and the applicable criminal procedure rules. They sought release on bail on reasonable terms, arguing that they are presumed innocent, have fixed places of abode within the court's jurisdiction. They have no known criminal convictions and had presented substantial sureties. They also undertook to comply with any bail conditions and not to abscond. The applicants further argued that although they had appeared before the Chief Magistrate's Court several times, they had not been committed to the High Court for trial and investigations were still ongoing. The respondents of the state's opposition was that the bail application, the prosecution, on the other hand, opposed this application by filing an affidavit sworn by Detective Assistant Superintendent of Police, Revuga John Mary. The respondent argued that the applicants should not be released because they face grave charges of terrorism, which attracts a severe penalty upon conviction. The respondent further contended that the applicants may abscond or interfere with investigations and witnesses, or even compromise public safety if released. It was also argued by the state that investigations were still ongoing, that some witnesses resident in Chibibi Town Council and Gombe Town Council, where some of the applicants were alleged to have lived. These are stations where some of the applicants in this matter is alleged to have influence, and that the proposed sureties were not also substantial. The respondents therefore asked the court to dismiss the application. I'll now go on to the legal principles relied upon by the court. The court reaffirmed that indeed under Article 23, Paragraph 6A of the Constitution, an accused person has a right to apply for bail. However, the grant or refusal of a bail application remains the discretion of the court. The court also relied on the constitutional presumption of innocence under Article 28(3)(a), emphasizing that every accused person is presumed innocent until proved guilty. The court further stated that bail should not be used as punishment and that an accused person should not be unreasonably deprived of liberty before conviction. The court relied on authorities including Uganda versus retired General Dr. Kiza, retired Colonel Dr. Kiza Besige, and Foundation for Human Rights Initiatives versus Attorney General. Importantly, the court held that an accused person does not have to prove exceptional circumstances in order to be granted bail. Exceptional circumstances are not a prerequisite for the grant of bail because the High Court has discretion to grant bail where appropriate. The court also emphasized that the purpose of bail is to secure the attendance of the accused persons in court. The key question is whether the accused is likely to appear for trial and comply with the bail terms. In considering the application, the court took into account factors under the Constitutional Bail Guidelines, specifically Section 16 and Section 16 of the Trial on Indictment Act, These include the gravity and nature of the offense, whether the accused has a fixed place of abode, whether there are sufficient sureties, and any likelihood of absconding, or possible interference with witnesses and public safety. Court also considers if there is any record of previous breach of bail or pending charges and the stage of the particular proceedings for which bail is sought.
After considering submissions from both sides, Justice Susan Okalanye granted Muwanga Kivumbi a cash bail of 10 million, while his co-accused were each granted cash bail of 1 million.
Each of the remaining sureties each of the remaining applicants shall execute a cash bond of Uganda shillings 1 million. For Mr. Kivumbi, 10 million shillings, and the rest 1 million shillings. For each surety, you shall execute a non-cash bond. Non-cash means you do not pay, but you're just committing yourself in writing. A non-cash bond of Uganda shillings 5 million shillings only. Applicants who own passports must deposit their valid passports and all travel documents with the Deputy Registrar, International Crimes Division. The applicants are prohibited from traveling outside Uganda without prior permission of the court. The Deputy Registrar shall inform immigration authorities of the restrictions and conditions governing the applicants' travel. Each applicant shall report in person once every month to both the Deputy Registrar of the International Crimes Division and the Chief Magistrate's Court of Butambala on the same day. Now, to avoid confusion, for purposes of those appearing before Butambala Chief Magistrate's Court, I want to believe you already have a date. So you're going to maintain the date that has already been given. And for purposes of this court, since I am the registrar, I'm going to maintain that you shall be reporting every last Friday of the month. So every last Friday of the month, you report to the Deputy Registrar at the ICD. Do not confuse the two and say I've already reported in one, so I'm not obliged. No, these are two different courts, with this one, of course, being the higher. The other order by the court is that if the applicants are committed to the High Court for trial, they shall thereafter report only to the Deputy Registrar of the International Crimes Division until the trial date is fixed. It means once the prosecution goes ahead and commits you for trial, you will stop appearing in the lower court because the file technically will leave and the Chief Magistrate will cease to have any business in this case. Now, if the applicants are not committed for trial within 1 year from the date of this ruling, which is today 9th July 2026, they may apply to the court for review of the bail terms and conditions or any other orders. Okay, that is for the prosecution specifically to note. So this was the ruling of Honorable Lady Justice Susan Okalanye. Mine was just to really read it, and I think I've done that. The document is signed today, the 9th of July, 2026.
In her ruling, Justice Okalanye held that the successful applicants have presented substantial sureties and had satisfied the court that they will not interfere with the ongoing investigations, nor endanger the public if released on bail.
The court further held that allegations that an accused person may abscond interfere with witnesses, compromise investigations, or endanger public safety must be supported by evidence. Such allegations cannot be based on speculation or general apprehension. The court's finding. The court found that all the applicants had demonstrated fixed places of abode within the jurisdiction of the court. This was supported by local council introduction letters, identification documents. The respondents did not produce sufficient evidence to rebut the applicant's claim of residence. On sureties, the court emphasized that the purpose of a surety is not merely financial capacity to pay a bond. The key consideration is whether the surety has sufficient knowledge of the accused, a close relationship, moral authority, proximity, and the ability to account for the accused person's whereabouts. On the gravity of the offense, the court acknowledged that terrorism is indeed a serious offense and that the charge carries a severe penalty. However, the court held that the seriousness of the offense alone is not sufficient to deny bail. At the bail stage, the court is not determining guilt or innocence. On alleged interference with investigations or witnesses, the court found that the respondent had not produced concrete evidence to show that the applicants would indeed interfere with witnesses or investigations if released. The court held that the fact that investigations are ongoing does not by itself justify continued detention. On public safety, the court acknowledged that terrorism offenses raise public interest and security concerns. However, it found that the respondent had not produced evidence showing that the applicants' release would endanger the public or compromise community safety. The court also found no evidence that the applicants had previously breached bail terms or had other pending charges. Now, the Rashadas Dandi, or the reason for granting bail. The court granted bail. The court, being satisfied that the applicants had generally demonstrated fixed place of abode within the court's jurisdiction. The 10th applicant, Muwanga Brian. The 21st applicant, Akankwasa Ivan. The 22nd applicant, Yusuf Ramadan Chiwanuka. And lastly, the 23rd applicant, Owori Brian. The court directed that these applicants present additional proposed sureties for examination on the 13th of July, 2026. So in summary, bail was granted with the exception of the 6 accused persons.
The court also imposes strict bail conditions, including a requirement that the accused must not leave the country without prior permission of the court.
Applicants who own passports must deposit their valid passports and all travel documents with the deputy registrar. So every last Friday of the month, you report to the deputy registrar at the ICD.
The 6 accused persons, however, were denied bail, and these include Kelvin Kayanja, Brian Sewanyana, Brian Muwanga, Ivan Akankwasa, Chiwanuka Ramadan, and Brian Awol.
So I'm going to give you exactly why these particular accused persons. The 7th applicant, that is Kayanja Calvin, presented 2 proposed sureties who were childhood friends. Although they were identified by the LC1 chairperson and described as law-abiding, the court found that they did not have sufficient familiar ties or demonstrated moral authority over the applicant. The court therefore required the applicant to produce other sureties. In respect of Sewanyana Brian, he presented Ms. Nakalazi Sumaya and Mr. Richard Ntai as sureties. The court accepted Ms. Nakalazi Sumaya because she had a close and long-standing relationship with the applicant and knew his personal circumstances. However, the court rejected Mr. Richard Ntai because his relationship with the applicant was not sufficiently close or continuous. He had not visited the applicant's home, did not know the applicant's relatives, and gave inconsistent evidence regarding the applicant's telephone number, and the applicant was therefore required to produce another surety. So you have one surety, Nakalazi Sumaya. You need to get another one. On the 10th applicant, Muwanga Brian, the court rejected Mr. Muwanga Yusuf because his testimony raised credibility concerns, especially regarding his education, employment, and the court found that he was not entirely truthful from the start. Although the court's reasoning found the applicant's wife and another surety substantial, the final order lists the 10th applicant among those required to submit additional sureties. With respect to Akankwasa Ivan, the court rejected the sureties presented. The court found that the proposed sureties did not demonstrate sufficient moral authority, close relationship, or ability to account for the applicant's whereabouts. One surety had known the applicant for only 6 months and had never visited his home or did not know where he resided. The court therefore required production of another surety. For Yusuf Ramadan Chiwanuka, the court was not satisfied with the proposed sureties. The court's concerns regarded the sufficiency of their relationship with the applicant, their moral authority over him, and their ability to account for his whereabouts. So for Ramadan, you're producing 3 fresh sureties. All your sureties were rejected. And lastly, for Owori Brian, the 23rd applicant, Owori Brian, was among those required to produce additional sureties for examination. The court was not satisfied with the sureties presented for purposes of immediate release. The accurate position, therefore, is that also, Owori Brian, you're going to have to produce 2 more sureties. Only one of your sureties was found to be competent. So the final orders. The court granted bail application subject to the following terms. The 7th, 9th, 10th, 21st, 22nd, and 23rd applicants shall submit additional sureties, proposed sureties for examination by the court on the 13th of July 2026.
They were directed to return to court on 13th July 2026 after securing substantial sureties.
A long haul. We made an application for bail way back in April. It has been a concerted effort of the legal team, the party, but especially the people of Tambala. It is that commitment that has helped us, enabled us, secure bail, because lawyers alone could not really succeed. We have the help of the party. The party and lawyers will not succeed without the assistance of what? The sureties and people of Tambala. So for whoever has contributed towards the release of the applicants, we appreciate. The terms granted by court, we appreciate that 6 persons have been granted bail, but they have not fulfilled the condition of substantiality of sureties. So,
nakolwaleero twebaza Katonda nti at least kooti etuwadde essuubi nti eno kooti y'abantu, kubanga ssemateeka ali very clear nti kooti zinaabanga z'abantu, zinaasalanga ensonga, era beiru enaabanga mandatory koyo alina ebisaanyizo ebifuna beiru. So twebaza Katonda nti Honorable Muwanga Kivumbi oluvannyuma lw'emyezi 6 n'ekitundu mu kkomera afunye obwenkanya. Ffe ng'abakulembeze bannabyabufuzi tuzzeemu amaanyi nti buli obasiba bannaffe mu mbeera ya bbira mupango ffe nebweru babanga batumalamu amaanyi. Naye nensaba ne bana abaana omukaaga abasigaziddwa nti tebaleeta beeyimirize basaanidde nsabaweebwa omukisa okweyimirirwa nga 13 naye nennyongera okukubiriza kooti zaffe nti ekyo kyetusuubira mu makooti era tukkiriza amazima n'obwenkanya nti guno omukaaga katwongere tuleete abajulizi abalala naye akakakkulizo ka miliyoni 10 cash miliyoni 10 ekyamazima nyingi bano abaana boolaba aba bulijjo akakadde nako kangi yes tujja kanoonya oba tutunze mwanya oba tutunze baffe tugenda kaleeta naye tusaba kooti naawe egonzeemu obukwakkulizo obwo engeri omuntu gy'abaleese abeeyimiriza abasaanidde obukwakkulizo obugondemukko kubanga ssente ezo nyingi nnyo ku muntu wa bulijjo naye nga tuli basanyufu twebaza Katonda olw'ekino kyatukoledde olwaleero era ne Muwanga Kivumbi ne tusaba Allah amuwe obugumu ng'afulumya ebweru asobole omukozesa eby'amaanyi n'okulwanirira ensi yaabwe ne bannabutambala tubeebaza bayimiridde ne Honorable Muwanga emyezi 6 n'ekitundu gy'abadde ng'atambula ng'ajja mu kkooti tusaba Allah abawe ekisingayo obulungi
bya birimu abadde omutono ngeze n'ogejja era Mukama akoze maanyi Mukama w'amaanyi Mukama tuzadde n'awulira bikamaliyo n'akoze bikamaliyo annyambye kojjanga okulaba nti atebwa oba mumanyo g'empiki tweyanziza Katonda tweyanze nnyo bigira tujja kwongera okusaba n'okweyanza tujja kweyanza nnyo tweyanze nnyo era yeetagayo ekikolwa ekya sapuli agereki tweyanze nnyo tweyanze
sanyu jereere eriffe bannaguleta mpigi nti mukama waffe deputy president waffe bamuwadde bbeeru bamubakkiriza okweyimirirwa era bannaffe omukaaga abakyalaalidde tumanyi nti nga 13 olaba guno gwe gubadde gusinga obunene tugenda kunoonya ababeeyimirira kubanga be babaddeko ensonga abali substantial tubeere nga nabo tubajja mu nkomyo naye nga kitiibwa n'ettendo
bateereddwako obogera kooti
ya obukwakkulizo okuba nti Honorable Muwanga waayo miliyoni 10 tulowooza nti nyingi naye eddembe lisinga ssente so ne bwe kuba kuzinoonya n'abaana abo ababadde mu kkomera famire zaabwe tezirina kakadde naye fe abali ebweru katulabe nga tukola mobilization bafune eddembe lyabwe ate bagende baweereze eggwanga lyabwe.
Mbadde omu ku abo ababaddewo nga tukakasa omulamuzi wa Crime Division Court nga Honorable Muwanga Kivumbi n'abalala ababadde ku fayiro eno kakaluka kooti ssente ez'obulwo miliyoni 10 ate bano abalala miliyoni 1 wabula waliwo omukaaga watasobodde kuta n'asaba guleetebwe ng'ennaku z'omwezi 13 babeere nga nabo bajja ne basurities oba babeeyimirira abalina ebisaanyizo ebisaanidde. Twebaza kooti olw'okukkiriza nti okukkiriza mu ssemateeka nti omuntu yenna abeera innocent until proved guilty era bail bimu ku constitutional mandate oba bimu obwakatirwa bwe tulina okuyita mu mateeka obuweebwa omuntu ddembe lya muntu okubeera nga yeeyimirirwa naye n'emisango mulaba nti emisango egyali gyajweteka Honorable Muwanga Kivumbi weesanga nti engeri gye gyajjizibwamu teyalina mundu nti alina essasi lyakwata natta omuntu tuvumirira ebikolwa ebyo ebyokutwebola eddembe ly'obuntu naye ntubayozaayoza obusibe buggwa obwo twasobodde bakyalirako ekitalya n'abalala abasigaddeyo tulina bannaffe abamu bamachete bakato bakavuma n'abalala babadde ekitalya okumala emyaka nga 6 baana bano okuva guno omwaka gwatandika ndooza mu January lwe baakoma okutwalibwa mu kooti ensukkulumu yawa ensala nti abantu ba bulijjo tebalina kugezesebwa mu kooti ez'amagye naye ne bagenda ne bakola amendment mu parliament era ne bagamba nti abantu ba bulijjo basobola okugezesebwa oba civilian basobola okutwalibwa mu kooti ey'amagye naye okuva ensala eyo yaliwo abantu abo tebagendanga mu kooti martial era badimandinga nti kale bwe bamugamba nti kooti martial erina obuyinza obubawozesa babayite babawozese babobiyanga bamachete bakatoomalu n'abalala tusaba kooti singa kooti endala zeemulatinga oba zikola kino kooti kyekoze osanga eddembe lijja kubanga abantu basobola okubeera nga balyeyagaliramu.
Twebaza kisooka twebaza Katonda ekiseera mwami Muwanga gy'amaze omukomera wamu ne banne kinene nnyo ate nga tusuubira olw'okuba tannaba kusalibwa kitalina musango. Twebaza n'omulamuzi akoze kino kubanga President Museveni abadde yakwogera ebiseera ebyo takkiriza tayagala beero z'abapolitician kyetulowooza nti kikyamu
president tateekwa kweyingiza mu nkola yaki ya kooti. Kooti esazeewo era ndowooza kino tekikoma ku Muwanga yekka. Muwanga lwa abaana bangi nnyo abaakwatibwa, baana bali mu makomera bayitirivu nnyo, n'abalamuzi abalala bakolere ku kino. Tebafaayo President Museveni oba ayogedde oba tayogera, era tuvumirira President Museveni kooti azireke zeetaaye, naye nga bw'alina executive ye bw'agikozesa ne court judiciary naye azireke. N'olwekyo tusuubira nti kino kye kikoleddwa ku Muwanga ne banne, n'abasigadde bonna babate. Mufumbiro bali mu gundi bali mu kkomera, ba Kivumbi bali mu kkomera, ba Edi Muto bali mu kkomera. N'olwekyo abaana abo bonna babate, then gye banava kooti ekola omulimu gwayo, naye twebaza kooti.
Takbir. Aha. Owulira otya?
Nze kuwange nsooka okwebaza Allah subhanahu wa ta'ala, ne neebaza abantu b'e Butambala n'abantu b'oku Kampala kwonna batukwatiddeko mu kusoma essaala zaabwe, ab'amaduwa gaabwe nga bali mu kulaajanira Allah abeere ng'atugondeza ensonga eno. Mukama Katonda tumwebazizza olw'okutugondeza ensonga eno, newankubadde nga wasigaddeyo abaana baffe, naye tulina essuubi nti nabo bajja kuvaayo. Ate era nga tulina n'ekyetulindirira Mukama Katonda nakyo tukusaba kibeere nga kigguka, ensonga zonna ziggwewo. Mukama Katonda weebale nnyo, weebalire ddala. Ne bannabutambala mwebale okubeera abagumu, mwebale okubeera nga muli ku nsonga yennyini. Mukama Katonda abawe obuwanguzi.
Amina. Yesanga tena muno wekitiibwa Honorable Muwanga Kivumbi ateereddwa afunye beyiro yesokedde singa okututta kubanga olw'ensonga alina emirimu gye ng'omuntu. Amulaba embeera y'ekkomera si nnungi, era buntu bwaba avuddeyo ajja kufuna beyiro adde nga mu kooti awoze emisango gye gikole ekigiggwe. Mazima n'obwenkanya naye kale tutuuse tuza ofuna ku mazima n'obwenkanya. Bannabutambala mwebale nnyo bali ddala, ne bannamateeka abaffe tusiimidde ddala ne President.
Prosecution alleges that Muhammadi Muwanga Kivumbi, together with the 22 co-accused and others still at large, committed acts of terrorism between 11th and 17th January 2026 in various parts of Uganda, including Kibibi Town Council and Gombe Town Council in Butambala district. It is also alleged that their acts were intended to influence the government and intimidate the public for political or economic purposes. The alleged acts included attacks on Kibibi Police Station and Butambala Electoral Commission Tale Center, destruction of sections of the Butambala-Gomba Road, damage of several motor vehicles, and incidents that resulted in the death of Sala Naiga, Aisha Nabukenya, Miri Nampereza, Ruth Nakanjako, Abdul Nur Musamo, Shafiki Miro, and Davis Basaliza. The accused are waiting to be committed to the International War Crimes Division High Court to start their trial